Ma'am, with your permission, may we begin?
Yes, good morning, good evening.
A very good evening to one and all present here. I am Atithi Abhay, taking this opportunity to welcome you all on the finale of special lecture series on the topic Mediation and Conciliation, Recent Development, organized by Maharashtra National Law University, Mumbai in association with the Family Court Bar Association. Before we begin, I would like to give you a brief introduction about the university, that is MNLU Mumbai. Maharashtra National Law University, Mumbai is one of the premier national law institutes in India. The university was established in the year 2014 when it started its first academic endeavor in 2015. The university disseminates advanced legal knowledge under the able guidance and mentorship of university's Chancellor, Honorable Mr. Justice D.Y. Chandrachud, and under the able leadership of Honorable Vice Chancellor, Professor Dr. Dilip Ukesa. MNLU Mumbai also lays its emphasis on research projects, clinical exercises, legal skills, training, legal research, and mooting by encouraging its students to represent university in national and international competitions. We have various centers established to conduct advanced research like Center for Arbitration, Center for Information Communication and Technology, Center for Research in Criminal Justice, Center for Clinical Research, Clinical Legal Education, Center for Maritime Law and Research, Justice M.L. Finzi, Chair in Environmental Laws, and many more. About the Family Court Bar Association. The Family Court Bar Association is a professional body of lawyers that promote conciliation and secure speedy settlement for dispute relating to marriage, family affairs, aiding the judges in administration of justice. And the purpose or aim of establishing a family court is to protect and preserve the institution of marriage and promote the welfare of children and provide settlement of disputes by conciliation, and by advocates of Family Court Bar Association are working hard to achieve this goal, ma'am. So, about the webinar. So, there is a need to understand the recent developments in mediation and conciliation and these techniques to resolve disputes and disagreements between the transacting parties and arriving at an amicable settlement. So, so that it provides speedy disposal of trial, economic settlement of dispute, and it is very time saving. Now, I invite amongst us Advocate Shashidharan Nair, Sir, President of Family Court Bar Association, Mumbai, for the welcome address. Sir, over to you.
Hello, good evening. Good evening, everybody. Yes, Christie Madam, we are very happy. Last 5 to 6 days you are with us, and we are discussing various aspects about all the forms of ADR, especially arbitration, conciliation, and mediation. I also participated much of the part of the lecture. I'm also happy. Many developments which is in Indian law, also you are very thorough, and it is enlightened us. We are especially thanking you. And of course, there is a very, very close relationship between Family Court Bar Association and MNLU. We are doing so many things together. Again, it is very glad to inform you that next month from 19th to 25th, there is again a mediation, complete workshop is going on in MNLU, and we are also participating. Many of our lawyers are there. So your inspiration as well as your speeches and your updating, that is basically giving more enthusiasm and more knowledge to us to go ahead. We are thankful, madam, and you used your valuable time for meeting us, discussing with us as a family member. Of course, family court is always considering everybody as a family member. So in that aspect, all the respect to you. MNLU and Family Court Bar Association welcoming once again you for this wonderful lecture series. We are in the last day, but that is not the last. That should be a new beginning. And Nothing is ending. It is that's the beauty of life. Nothing is ending. We are ending and we are starting, and the ends, all the ends are for a new starting. So, Madam, please proceed. We all are with you. We are so thankful. And this occasion, I am congratulating as well as keeping very near to our heart MNLU, all the staff. Yeah, Vijay told that he is got some assignment, so Madam is there. We are welcoming everybody. Thank you. Please proceed. Thank you very much for one more time. Bye.
Without further delay, I would like to introduce you all amongst us, our chief guest. Ma'am, just 1 minute. Miss Christie Harrington, ma'am, received her undergraduate degree from Francis Marican University in Florence, South Carolina, with a BA in English and her law degree from the University of Tulsa College of Law. She was employed by the District Attorney's Office at Tulsa, where she began prosecuting juvenile and adult felony cases with a limited license to practice law. Upon graduation, she remained in the District Attorney's Office, where she implemented a domestic violence court. Upon returning to South Carolina, Christie ma'am became very active with the bar and her community. She still has she has also served and retired from the bench, and she's a certified Supreme Court mediator and arbitrator, owning her own alternative dispute resolution practice, Christie Harrington Dispute Resolution. She's honored to be on an American Arbitration Association, that is AAA's judicial panel, and a member of the Arbitral Women. Ma'am, over to you.
Thank you. And what a wonderful and warm welcome. And I love that it's not the end, it's a new beginning. And I look forward to working with you all as we proceed and have a vibrant mediation practice in India. So I'm going to share my PowerPoint. And I really just wanted today to be a wrap up of what we really had talked about. So just some takeaways and some final thoughts on where we are. I love this quote from Abraham Lincoln: "Discourage litigation, persuade your neighbor to compromise whenever you can. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough." And I think that really sums up what we have talked about for the last few sessions. Is mediation is different from litigation, but it really does help peace building, and it allows the lawyer to be a good person. So we're going to talk, I hadn't spoken much about Mediator's Proposal, and so we're going to spend some time talking about that subject. The Mediator's Proposal is a little controversial in the United States, but what is it? What is a mediator's proposal? A mediator's proposal can come really at any time in the mediation. We talked a lot about impasse and difficult clients. So what the mediator's proposal could do is, if the attorneys say, "Hey, Madam Mediator, we are at an impasse and we really don't know what else to do. What do you think we should do?" And this can come in several forms. It can be an oral proposal. It can be likely and most beneficial, a written proposal. And what that does is it outlines all of the issues, and the mediator puts in that proposal, puts in that order, suggested what he or she believes is going to be the outcome in a trial, or makes the recommendation of this is what should happen at this mediation. So think about one of the things I want you to think about, because I'm wanting you to have lots of tools to help settle these cases, to help resolve these cases. Remember, we don't want just a result, we want resolution. So think about, is this proposal even necessary? Maybe you should go back and continue to mediate. I think it's important at this point is to always remember attorneys and clients are operating on two different criteria and two different motivations during the mediation. Attorneys rely on the law. So attorneys are looking at whether or not, if we go in front of a judge, what is that judge going to look at in order to make that decision? Clients are considering other criteria. And some of those other criteria are things we've talked about. And one of the beautiful things about mediation is it's final. You don't have to go to court. You may or may not have to see the other party. Costs, all those things, saving honor, avoiding shame. So clients are considering other criteria other than the law. So keeping that in mind may help move a client who is focused on things that are not going to move the needle towards settlement. If the client is concerned about being correct, getting, his or her day in court, that may not be the thing that's going to help legally resolve this matter. So what are the risks of a mediator's proposal, or really why is a mediator's proposal controversial? Seems a pretty natural part of a mediator's role, right? Especially if we're engaging in an evaluative model, not a facilitative model. And so here's something. The mediator will only know what the parties have told the mediator. Somewhat true to what a judge may know, right? A judge may only know what the parties have been told, but the judge also has the ability to do independent research that the mediator may not have access to. If you engage in a mediator's proposal and you are the attorney and you just tell your client, well, we're going to wait to see what the mediator says, you are really taking away the autonomy and authority of that client to actively participate. Remember, we talked day one, the mediator controls the process, the parties control the outcome. And using this mediator's proposal sometimes tends to take away from the parties' participation. Think about, are you really wanting to move from this facilitative process into a more neutral evaluation, meaning that the mediator is going to make those decisions? And then you've got to be concerned as a mediator, are you giving legal advice? And so then you've got to do that analysis, and that's just from the point of the mediator. So I think sometimes a mediator's proposal can move this process along, especially if the parties become very entrenched. But I point this out and I highlight the risks because using the mediator's proposal really moves this from not a traditional model of mediation. So we talked about moving the mediator's proposal, really that makes the mediation an evaluation. So we have in South Carolina and in the United States an early neutral evaluation concept. This is separate and distinct from the mediator's proposal. This is where a party, and typically both parties, will seek the advice of a mediator, judge or attorney concerning the strength of their case. And the primary goal is to get the parties to focus, again, on the strengths and weaknesses. Maybe this is the time that you're really focusing on the law and how those weaknesses are going to impact the understanding by the judge of this case. The neutral renders an advisory, non-binding decision that's essentially a prediction of the outcome. And again, all of those things that we talked about before in the previous slide is to a risk. Again, the neutral is rendering a decision based upon what the neutral has been told. And so these are allowed in the rules and encouraged because it usually helps avoid expensive discovery expenses, unnecessary pretrial expenses. So these are two things we did not talk about in previous sessions, but I wanted to point these out, that there are alternatives and different ways to use a mediator, an experienced neutral, in order to resolve your matters. So has anybody ever used a mediator's proposal or an early neutral evaluation in your cases? You want to just unmute or put something in the chat tool? Dr. Bengali, I saw your smiling face. Are early neutral evaluations used commonly in India? So think about how these techniques could be used or how you could incorporate these into your mediation practice. Maybe having an early neutral evaluation, either calling a mediator or someone experienced, a retired judge or someone of that nature to evaluate the case, maybe having your client present where they can hear the questions that are going to be asked and then see the evaluation, that decision that the neutral provides. The mediator's proposal can typically come at any point in a mediation, but again, be aware of all of the risks. So I just want again to highlight, because we can work very hard and get an agreement, but if we don't reduce it to writing, we don't have an agreement that we can enforce. And so I think what happens a lot of times is everybody's so tired and we're so excited to get to the finish line, so to speak, that we forget the small details in the settlement. And so one of the first things that you should do is make sure that all of the discussions that you've had throughout this mediation have been summarized and everybody is very clear. So you can have your mediator do that. You as counsel, when your client is speaking with the mediator, you can begin to bullet point the discussions. But those are really important because tomorrow you may not remember what was said yesterday. And so summarizing the discussions is really important, even if you get just that language, client X agrees to pay client Y $25,000. The discussions are really important because those details are, well, how is the client going to pay? Where will the client pay? By what date? And so having those discussions summarized really helps all the parties articulate and identify those issues and areas where the settlement could fail. Be careful with the boilerplate language. And I had indicated in previous sessions, I carry just a basic template, sample form that I can fill in. But be careful if you have a template that you use that you are able to, that you really do read through and check to make sure that you're not leaving in something that doesn't apply, or that will change the meaning of the language. You should anticipate disagreement. The parties did not come to mediation with you because they were in agreement. They came to a mediation because they were disagreeing, and you should anticipate that unless everything is spelled out, that there will be disagreement. So that helps you plan for the failure. What's going to happen if client X does not pay client Y? Are you going to come back to mediation? If you come back to mediation, are you going to use the same mediator? If you use the same mediator, who's going to pay? So there's all of these questions that you can anticipate. And I do find that this is an opportunity to really articulate and specify what does happen. I think a lot of times we may think to ourselves as counsel and as a mediator, okay, well, I'm writing this agreement, and then if it doesn't work the way that we want it to, if the parties do not comply with the language, then they'll just go in front of the court. But this is also an opportunity for you to lay out the details of what's going to happen if that does not work out. And I think that's really important too. Maybe putting in their language, come back before you can file suit. You must come back to the mediator for an attempt to resolve. And I think that also then adds credibility and enforcement to your settlement agreement. I believe the counsel should prepare, and I see a lot of times everybody wants to leave, and it's usually who has a laptop at the mediation is the one that's preparing the settlement agreement. But think about who really should be preparing that. And most of us are type A, very organized and in control of our dockets and our clients and our cases. And so maybe you should be the one. Make sure that you put some language in there that these are the facts known. What happens if there is a piece of property in the divorce settlement that is not addressed, and you find out about that later? How are you going to address all of those things? Maybe there's a pending lawsuit in a commercial litigation that you didn't know, and having those understandings of this is a settlement based upon the mediation that occurred today can also help you anticipate disagreements or plan for any unforeseen circumstances that may arise. One of the things that always seems to be a little tricky is who keeps the original agreement? Who keeps that signed agreement? As a mediator, I do not want to keep the original. I typically, and I lay this out in my opening with the parties, is I destroy my files after a certain period, maybe 6 months. But whatever that time frame is I let the parties know I will be destroying all my notes, all the agreements, so that, again, the rules don't allow me to be called to testify, but then I just don't have any notes. And then that is also another layer of protecting confidentiality. But who keeps the original? Does the moving party, does the party who has the burden or the obligations to complete the agreement? So work those things out, because there can only be one original. The original settlement agreement, the mediation agreement, does not make it to a court record here in the United States. And I don't think, based upon what I saw in those cases we've talked about previously, I don't think that would go. Do you need an approval of your settlement on the record in order for it to be valid? Sometimes you may want that to happen. You may want to go in front of the court and place it on the record in front of a court reporter. So circuit courts in South Carolina, courts of record, and what that means is that everything that is said in front of the judge is taken down, transcribed by a court reporter. And so when you place that on the record, that does become part of the court's file. And that will help, again, if you have a failure of one party to comply with the settlement terms is under the rules of civil procedure, then the court then has jurisdiction over the settlement agreement. But it does not mean that every one of your agreements has to be placed on the record. I would only say probably 10% of the mediations that I do, then we follow up by placing the settlement, the full settlement on the record. So is there anybody that can think about one of those things kind of triggered? Is there, you've had an agreement failed, and one of those techniques we just talked about, you're like, gosh, I wish I had known that 2 months ago. That likely could have helped that from failing. Any questions about the settlements, putting them in writing, or any questions about those? So just as you're listening to this presentation and you're thinking about that time when you didn't have a settlement agreement that that worked, or you got a call maybe 3 months later, hey, client X still has not paid me, what do I do? Then, you know, thinking about what could you have done differently, because if you're like I am, I like to, once I complete a case, I like to close that case. I don't like things popping back up. And so thinking today what you can do for your next mediation that can prevent that from happening, I think is really effective. And helping your mediator at the end when everybody is really tired and we just want to leave can really be beneficial. So here's some tips that I give to mediators post-mediation, and I think that's helpful for you as counsel to think about what should a mediator do. Make sure that you prepared your proof of ADR, and again, we've talked about that what you put in there, specifically in India, especially if your case has not settled. You make sure you file your proof of ADR with the court in a timely manner and provide copies to the parties. I think that is really important, that the copies are provided to the parties. Once I get a filed stamped copy from the court, then I prepare my thank you note and statement of services along to both counsel so that they are provided that filed copy. I send a statement of services. I am not court affiliated for my mediation, and I am considered a private mediator, but consider, sending your statement of services and include what you did during those services. Here in the United States, specifically in South Carolina, even if you are court appointed, you get some study time allotted, meaning preparation for the mediation. Some mediators charge for travel to and from the mediation location. So that has cut down quite a bit with the virtual mediations, but those would be a cost. And those are things as counsel you need to be aware of, that cost, there is a cost for mediations, especially private mediations. I think it's nice to send a note to counsel and to the pro se parties, and if you did reach a resolution, to congratulate them on resolving the matter, not in the result, but in the resolution of this case. The survey of mediation process, I think, is, especially for new mediators, or if you are trying out a new location or something of that nature, having a survey of the mediation process that goes to counsel and to the parties, asking about the facilities. Did you think the mediator was neutral? Did the mediator listen? And all of those things, the highlights that we had talked about. So I think it's really important also for the mediator to come back to his or her office and sit down and really do a deep dive into what worked, what didn't work, do your own survey of the mediation process. Just in the last slide, when I asked counsel to think about what worked, what didn't work, I also, after mediation, come back and say, what could I have done differently that would have allowed the parties to reach a different solution if they did not resolve the case? So is there something that somebody would like to share in your next mediation when you get called to do a mediation that from this presentation or one of the previous presentations that you are going to definitely take that and use that? Anybody like to share something that particularly they found useful?
Ma'am, hope I'm audible now.
Yes.
Okay. Hi. Ma'am, a small question that usually what happens is that, mostly I'm involved with some kind of companies where, mediation sometimes goes out without having too much of difficulty as such. But sometimes those technological barriers also do come. Like, for example, during the COVID, we have seen that some of the technologies which we used have some of the companies were very much open with their mind to adopt it and go ahead with it, and some of them are absolutely not ready to do it or use it. And there is also a frequent understanding that once it is being done online, offline, whatever way we choose to, still people have some reservations stating that no, we didn't agree on this previously. Now, already people have seen that, I mean, we all know that when it is mediation offline, people are very much eager, settlement agreements do come. But the time span I would like to ask about, because, what happens usually, at least in last 2 years, I have seen this, that once it has come forward that, yes, we will be coming down to some kind of settlement, how much time you think should be proper to close those settlements? Because I think when you find it difficult, especially in the field of technology, that these kind of mediations do work, but again, like, people want to come out with new ideas again, because there is still a calculation going on in the mind of the client that how far it is feasible for me. So suppose after a point of time, like, he wants to add something or withdraw something, how do you see it? Like, how much time you think is proper? Because I don't think every single time we find out some provision or something to support the timeline.
So I think every case is, thank you for your question. I think every case is different, and it really, I'm in the process of closing settlement on a what I consider a small case of $25,000. It has taken me 2 weeks to get the parties, because there's all of those things, back to, let me see if I can go, back to making sure all the facts were known. When we went into mediation, not all the facts were known. There was an outstanding medical bill, so there were some other things in play. And so that case is taken, and I will prepare the documents today. But we started that mediation 2 weeks ago, and I've just been able to continue that. So don't think that it's small cases should be small time. Sometimes those smaller cases take just as long. What I find is a lot of times in the bigger cases, that's bigger money or larger issues, especially with companies, people already come with this plan to succeed. They already know all the facts. Counsel is prepared. And so sometimes you are able to agree right away. What I think is the most important takeaway is get the agreements, all the agreements on the record. You may not totally resolve the issue, but you can have smaller issues that have resolved. So if, in an example with a family court case, maybe we can't decide on custody today, but we can decide on who is going to receive the house. So maybe highlighting those small wins. And so in the technology situation, I had a multi-million-dollar case, more than $40 million that was in dispute that I was resolving. And it took almost 3 months to resolve all of the parties who were at the table. And so I love that question because there is no right or wrong answer as long as you are maintaining the integrity of the process. And I think sometimes the longer discussions and negotiations, you tend to kind of move into where maybe it's a mediator's proposal, or you're just really moving numbers back and forth. So keeping in mind what you're doing, there's a lot we can, as we see, I don't have to fly to India to give this presentation, but there may be some points. If I were giving this presentation in person, we would be doing negotiations, mock negotiations. So I think sometimes there is a need to be in person. And so maybe getting as much as you can do out of the way and then meeting in person also is helpful. Did that answer your question, Dr. Bengali?
Yes. Thank you so much.
Thank you. Any other questions about key takeaways? So I wanted to talk about some of the things that I think are great takeaways that I forget a lot. To tackle the problem, don't tackle the person. And I know especially when you're dealing in family court issues, a lot of times you just truly, literally and figuratively want to tackle the other person. It's the problem, and we are focused on getting a resolution, not a particular result. And I think if you didn't hear anything else that I said, those two things are really important because that's where we need to focus. And I think that's where really good mediators focus and can get that resolution. Improve your listening skills. I know, one of the biggest is familiarity, and the more that you are around your client, maybe you stop listening because you think you've already heard it before. Work on your listening skills. I think that is one thing that attorneys really can spend some time on, improving your listening skills. Make sure that you're asking good, open-ended questions of your client, of opposing counsel, and avoid the why, because that puts people on the defensive. And what I started with and what I'll finish with is the mediator controls the process of the mediation, what that looks like, where we are, where the people are sitting, but the parties are controlling the outcome. And keeping those 5 points in mind will lead to a successful resolution, I am sure. Any questions about my key takeaways? Do you agree that those were 5 good takeaways? So I've got just
Like the
Yes.
first one, tackle the problem, not the person.
Yeah, I think that's really where we get in trouble is, especially even in business, right? That it's easy to attack a store, and so sometimes taking a step back and saying this isn't about what Walmart did wrong or Microsoft did wrong or Toyota did wrong. This is about the problem, and we need to tackle this problem, and we can tackle it. You can tackle it together. Another one that I didn't put up there but I struggle with is that we versus you, because remember, mediator, it's not mediator's problem, it's the party's problem. But I think that keeping in mind that the mediator controls the process is really important. So I like that one. I'm glad I put that one first, because I think that from that one, all else flows, especially in family court litigation and mediation. I think it becomes necessarily a me versus them situation, and moving forward, you've got to get past that. It's the problem to get this resolved. Any other questions? So I knew I would have a little bit of time left, and so there was quite a bit of questions about my slides on bias, and so I put together just a brief explanation on bias. Dr. Bengali may see this. These are some slides that I used previously when I did a presentation in Pune with him, a little more updated, but just to give the idea, and because I really do think sometimes going back to this tackle the problem, not the person, sometimes that person, we have a bias, implicit or explicit, against that person. So when we talk about implicit bias, we're talking about something that's internal. And then when we talk about explicit bias, they're attitudes that are at the conscious level, they're deliberately formed, and they're easy to self-report, right? So I know Dr. Bengali is a huge cricket fan, and I don't know what team he pulls for or roots for, but if he were out with some friends and he saw the person across the room with the same cricket jersey on, he would immediately go, I like that person, right? And that's because he's consciously noticing the jersey, and he determined that because I like that team, everybody that wears that jersey must be great like I am, okay? You have that conscious level, you see the jersey, it was deliberately formed because you chose one team over the other, right? So we just had our Super Bowl, and not to upset anybody, but I was not rooting for the Bengals. I am not a fan of the Bengals. And so I consciously have formed an opinion. My bias is against the Bengals, right? So this is an easy one. Nobody's getting hurt because, or shouldn't, because I wear a certain color jersey. But so this is easy for us to identify. Implicit biases, in contrast, are attitudes at the unconscious level, involuntarily formed, and typically unknown to us. Instead of implicit, I have started using unconscious. So, but the terminology, until the trend changes fully, the trend is implicit, explicit, but implicit can be used interchangeably with unconscious. So unconscious, involuntary form, and typically unknown to us. So here's an example. Greg is a middle-class white man, generally believes that everybody is equal, despises racial bias. So if you talk to Greg, he's going to tell you, I have no bias, all races are equal, and that's his belief. He can share that with others. but he is unaware that any time an individual of Hispanic origin comes around, he begins to act nervous. And so he needs to think about if Greg, maybe he grew up in a town with negative stereotypes about Hispanic people, that some of those may have influenced him without his knowledge. So maybe your home of origin has these types of stereotypes. They're subconsciously shared. So he has a contradicting implicit attitude. So his behavior does not necessarily match what he's saying. And so this is where mediators can get into trouble, right? I can say all day long, I am fair and neutral. But if a Hispanic person walks in and I share Greg's implicit bias, I might unconsciously be sharing, and that person may think that I am not being fair or neutral, and that could affect the outcome of the mediation. So this is where we use we, because I think it's really important for all of us to be a we together in challenging our biases, to make ourselves aware of them. And really, these are not good or bad, and we shouldn't think of Greg as a bad person because he has implicit bias, or Dr. Bengali as a good person because he wears the right cricket jersey, right? We must be determined to find and to challenge them. And so where it is important for lawyers, for counsel, and for mediators and judges, I do a very similar presentation for judges, that you've got to be able to learn. You just got to know. So if you know that you have a particular strong feeling about single moms, that they should be, they're lazy, or they're not working hard enough, or they shouldn't be single moms, that as a judge, if a single mom comes in front of you, you need to be very aware of your own bias and make sure that you challenge your prejudices before you act on them. And that's really all this discussion is being aware before you act on them. Implicit stereotypes and implicit attitudes. So unconscious stereotypes, unconscious attitudes. Stereotypes are traits or characteristics that we associate with a category. Attitudes are evaluative feelings that are positive or negative, right? And so, think about, I'm going to share this PowerPoint. These are really good videos for you to watch. I have permission from the district court in Washington to share these videos, but please don't share the videos beyond your own viewing unless you also get permission. That's my public service. But this is and I think it's really interesting, they show before jury selection, they show this bias of jurors. And what you're going to see is they talk about, just because you think a judge should look a certain way, don't be biased towards that judge, because he or she does not look that way. Likewise, they go through, if you see an attorney and you think all attorneys should be male and the attorney in this case is a female, do not let that impact your decision making. So I think these are nice. They're not very long, but they are very helpful. And I just thought that these could be used for your later viewing. So microaggressions, and this is probably where you would see behavior when I mentioned Greg and the Hispanic individual, that there might be verbal or environmental indignity. So maybe if the mediator was Greg would place the Hispanic male at a different place at the table than he normally would for a white male. And these could be intentional or unintentional, and they're typically based upon race, gender, sexual orientation, ethnicity, disability, right? Age is also one that there could potentially be implicit bias. So I don't want anybody to shout these out. And again, we all have implicit bias: race, religion, marital status, economic status, sexual orientation. These are all places where these unconscious biases may arise. So think of stereotypes, and so these are common stereotypes in the United States, with the dumb blonde, right? That of course she can't be very smart because she's blonde. We've got the computer. That's for those of you who are younger than I am, that is a computer back in the old with the floppy disks. and so then the bottom with the male and the female, most people assume that she's the nurse and he's the doctor. And that's kind of those implicit unconscious biases. So when I would appear in a courthouse, because I traveled all over our state, people thought I was either the court reporter or the law clerk. They never assumed I was the judge, because there were no such things as male judges. So think about those biases when you are working with your client and with your mediator. So here's some other stereotypes. Homeless. There's automatically, I can just show these pictures and your mind is probably already has put stories behind all of these pictures, that the homeless man must be lazy and not working and all of those things, a drug addict, alcoholic, that the child doesn't have good parents, letting them eat, right? So all of these things, and I just put the Trump Capitol picture because we could spend a lot of time about implicit bias, but that's something where automatically people see a Trump sign and there's dialogue going on in their head. So this is a great study. It's done by Harvard, and you can take it, and so again, you'll have the ability to click on those. You can take a test and you identify, and it will help you to identify your own biases. So how do you change your behavior? Just increasing exposure and interaction from people you have a bias against, or potentially. I think it's, everybody's got a Facebook page or some sort of social media. If everybody looks like you, that's likely going to be an issue. You need to expand your friendships from, gender and race and age. And, one of the things that I loved about my experience in India is the exposure from people all over various ages and races and religions, economic and social groups. And that's really what helps you work through these biases. But I want you to think about this, again, applying in the mediation room. Who is in the room? Whose voice is being heard and whose isn't even there? When I first started mediating, I mediated a case, and the injured party was female. Everybody else in the room was male except for me, and we resolved the matter. And I was speaking to the attorney, and he said something like, "Oh, well, I've never seen my client as responsive as she was to you." And I said, "Well, how many other times has she been the only woman in the room?" And he realized exactly that was what it was, is there was there was something going on, and her voice was not being heard in a way that she felt she was being heard. So thinking about who's at that room and who can help move that settlement is really important. I encourage you, if you don't do anything else, but take that Harvard study. I think it's just fascinating. So I teach a course on victimology, and so this is when we talk about implicit bias. It's real easy to look at the picture with the female in the black eye and think she's the victim, right? That's really easy. But what you don't see, right, is the hidden smiles or the hidden pain that's covered by the smiles you see. So getting past is that initial reaction is really important. And this is, I use this also when I'm talking about domestic violence, is you don't always have to have physical injuries for there to be abuse. And I think, changing those stereotypes is important. Understand this concept, and it can, there's ways throughout the court process that really triggers where bias can occur. The investigation, the sentencing by the judges, education and evaluation, all are really important, how we can mitigate the impact of bias. I like that, judges are supposed to be free from bias and are to be subjected to the rule of law, much more than that intended for common men. So when I teach judges, I use this quote because we as judges need to be very aware of our implicit unconscious bias and our explicit bias, because cases should be decided on merit, not the reputation or status of lawyer, the litigant, or passion or sympathy for any party or witness. And that's exactly what should be happening in the mediation room, arbitration, conciliation, all of these things. Cases should be decided not on the merit and not on this implicit and explicit bias. So just wanted to hit some highlights. We're almost at the end, but just wanted, in the Chief Justice's address that I have just read and reread at the Mediation Summit, India-Singapore Mediation Summit 2021, he highlights several reasons and that ADR has been has grown so much. One is judicial delays, that mediation really can help assist judges in all the cases with the backlogs and those things. So again, utilizing a very vibrant mediation practice and protocol is vitally important for any backlogs. And then that ADR increases this concept of access to justice, that there can be different ways to get your case resolved to the courthouse and out of the courthouse without the necessary expensive litigation, the unnecessary cost associated with trying cases, the psychological cost, especially to the family when the family court bar is really attempting to minimize the trauma to the institution of marriage and to children. So I am at the top of the hour and very, very just thankful for the opportunity to speak to you on mediation. As I hope you can tell, I'm very, very passionate about mediation and arbitration, all forms of alternative dispute resolution. I look forward to, at some point, talking to you again about techniques on reducing court backlog, and maybe not to this group, but to your family court judges, on how we can utilize a mandatory mediation program to do that. Again, please, here's my email address. I welcome any questions or comments. If you get into mediation and you just got, you need some questions, please send me an email. I would love to be a support in any way that I can as you're moving into this wonderful world of mediation, arbitration, and conciliation. So thank you.
Thank you so much, ma'am, for your words of wisdom. And I'm sure our participants have understood the topic thoroughly now. I would like to invite Advocate Dr. Swapnil Bengali, sir, Director for the Center for Information Communication Technology and Law at MNLU Mumbai, to propose a vote of thanks. Over to you, sir.
I hope I'm audible. Aditi?
Yes,
am I
sir.
audible?
Yes, sir.
Yeah, okay, thank you. Indeed, it was a pleasure. It's been, I think, ma'am has visited India last time in 2018-19, and before that, I think in 2015. So since then, it's been really a pleasure to know her as a, some people have that. I'm being slightly informal. I take this pleasure to be informal, slightly informal, because what I know about Christie ma'am is that first time when I met her, she was like I visited from Charleston to Pune, and that time I thought that it is probably a nice thing to know a judge from US, and then slowly we developed a very nice friendship. And luckily, for me, I think the majority of the areas that I had worked with is associated mostly with the technology and the new forms of laws which are coming up in relation to that. But somehow, after having an interaction with her, we could realize that there is too much to be done with respect to these new areas of law and obviously mediation. So that's all about the persona, that it tries to take you to that level where even if you try to go into that contemporary fields of law, still certain subject matters cannot be unnoticed, and that's where one should work. And definitely, as a person, I learned a lot from Christie ma'am during her stay in India, and otherwise also, because COVID has given this other option for us for communication. So thank you for that. Formally, I would like to say that out of her busy schedule with much of experience in relation to mediation and whatever things that she has been doing, not even as a judge but also as a contribution. Her contribution into academics is much more. Training the judges is also something which is always there on her card, not just in US but also in India. I've seen her actually training the judges. And obviously, with her busy schedule, she has taken time out for us and also adjusted with the timings. I know it's early morning there, so thank you very much, Christie ma'am. It's been really a pleasure. Obviously, as I always say, listening to you is always an interesting factor, because every time whatever we discuss, it's something new that is coming up. So thank you very much for that. I take this opportunity to officially thank you for your time, for your simplicity with which you have clarified most of the things. And yes, quoting my examples, yes, sometimes I do carry that bias when I see the t-shirts, dresses. So sometimes that view is required. So thank you very much. From MNLU, I think I should also say this, that you've been a huge contributor with respect to this academic endeavor that the university has. And no doubt, this was just the beginning. This was, I think, first or second time when we have been invited to deliver sessions to MNLU. And I must say that this opportunity will be extended in future endeavors. I'm just hoping that the way in which COVID situation is getting eased up in India, very soon we'll see that most of the classes and most of the things would settle down, and we will have an offline classes too. So very soon we will also like to extend this to the next level of partnership soon. Yeah, we'll communicate regarding that to you as well. Thank you so much, Christie ma'am. From the university point of view, it's always contributing to new areas of law, and definitely this has been something which is a very kind gesture from your end, that you accepted and you continuously took 5 different sessions for mediation. So thanks a lot. I must thank the FCB president, Nair sir. He's been the constant support to all of us in MNLU. And from my end, I would like to thank also all the participants as well as our Vice Chancellor, Dr. Dilip Ukesar, who is always a support to us, always gives that, with permissions, with all the kind of support that he gives. A big thank you to him. And also Registrar Sir and all my colleagues at MNLU. Atiti and Abhijit were constantly involved in communicating. So thanks to them and thanks to all participants. Thanks a lot.
Thank you so much, sir. And a big thank you to all the participants for being so patient and cooperative. With the permission of the chair, I declare closure of the program. Thank you.